Guest presenters. I've asked my network of resources to share with you information regarding their field of expertise. As a senior real estate specialist, I've spent the last 2 years building a very strong network of resources. These professionals will share information with you so our seniors and their families can make informed decisions. As a senior real estate specialist, I'm committed to educating my clients through my network of resources.
Hi, welcome. I'm Whitney Wilson, and today I have been asked by Kent Lee to discuss some changes that are coming to a VA benefit called Aid in Attendance. And I'd like to thank Kent for this opportunity to spread this awareness. So first of all, for most people, the question is, what the heck am I talking about when I talk about this VA benefit? If you are in the long-term care system, if you're looking at care for a loved one, for example, or worried about having to pay for care, you might not know that there is a VA benefit available to certain veterans that can help pay for long-term care. This can be care that comes into the home. It can be assisted living, memory care, personal care, even help pay for nursing home. So the benefit's excellent in that you can age wherever it is safe to age and wherever you want to age, and the VA will help pay for it. Now, the benefit is called out in the community the Aid in Attendance benefit. It's not the technical name of it, but that's what everyone calls it. That's what we're going to use today. So the Aid in Attendance benefit is available to wartime veterans or the surviving spouse of a wartime veteran. And there are some dates of service that help define what or who is a wartime veteran. And this is going to come up on your screen, these dates, so don't worry about writing them down. But in my area as an elder law attorney and the clients I deal with World War II veterans, which is people who served April of 1941 through December of 1946. You didn't have to serve that entire time, but those are the dates that Congress has defined World War II as beginning and ending. I also deal with Korean War veterans, and that started in June of 1950 and went through January of 1955. Then you have Vietnam veterans, and there are a couple different dates of service for Vietnam. Most are going to be 1964 to 1975. Some people might fall into a range of dates earlier, 1961 to 1975. Those are the wartime dates that I see most often as an elder law attorney. Now later on, we have the Gulf War veterans. That began in 1990 and has not been terminated yet by Congress. So given the dates or given the age that I deal with, long-term care is typically kind of older, natural aging process, starting to lose independence, and that's typically 65 and older, and so usually that's why I see the World War II, Korea, and Vietnam. Again, those dates are up on your screen. Now, this entryway into the benefit, these dates of service, are the first threshold that has to be met. If you didn't serve, you're surviving, if you're not the surviving spouse of someone who served in those dates, unfortunately the benefit's not available. The next framework to talk about, and again this is going to come up on your screen, is the amount that the VA will pay. It's important to know the amount strictly from the standpoint of stretching assets, helping pay for care so that you don't run out of money too quickly. And it's amazing how much longer money can last when the VA helps pay for this care. The care is very expensive for those of you who are in the system. So the VA pays the benefit based on certain categories. If you're the veteran and you're single, like if you're widowed or never married, Then they have a category for married veterans, so wartime vets who are currently married, and then the surviving spouse category. And the largest amount that you can receive under this benefit program is, in 2018, is $2,169 a month. $2,169. That is what's paid, the maximum amount paid to a married veteran. A single veteran, the maximum amount paid is $1,830 a month. That's for the aid in attendance, also called A&A, which you'll see up on your screen. And then the surviving spouse, their benefit is capped at $1,176 a month. So you can see, especially coming in at the $2,100 a month figure, that's a little over $24,000, about $26,000 a year. That is cash that the VA will deposit into your bank account and help pay for, again, this long-term care. But even as a surviving spouse, that's about $14,000 a year, and that's nothing to sneeze at, and it can certainly help stretch the assets so that you can afford to age wherever you want to. Now, the main reason Kent has me here speaking is because some of the other eligibility rules are changing. I went through the main one, the wartime service requirement. I have alluded to another requirement that you have to be, in need of long-term care. So in the eyes of the VA, you have to be disabled. You have to be needing care and paying for care. There's an income test, again, that concept of you have to be paying for care. But the biggest rule change is to the asset requirement. This benefit is a needs-based program. It's run by the VA through the federal government. It's similar to Medicaid, if you've heard of that benefit, run by the states, but this is run through the VA. So right now, the VA has had for many, many years this guideline of an $80,000 asset limit. It was not a hard and fast rule. If you were married, if you were younger or older, all impacted the net worth that the VA felt was appropriate for you to have. And it made the processing and the approval of claims very sporadic. People with, $30,000 in assets could get denied. And people, in theory, people with $100,000 in assets could get approved. And there was a lot of concern over that. So one of the new rules is a hard and fast asset limit of $123,000. Now again, that's for 2018. All these numbers change annually. If you're married vet, if you're a surviving spouse or single vet, the asset limit's the same for everyone, $123,000 for 2018. Another very interesting change is the concept of a look-back period. Again, if you're familiar with Medicaid has a 5-year look-back, and they penalize you if you give assets away within those 5 years. VA has never had that. You were allowed to, give assets away. You were allowed to use a trust to try and shift assets and reduce your net worth. And there was no look back on that. There was no question when you applied, what have you done with your money? The VA has changed that rule, or the new rule that's coming changes that. The VA is implementing a 3-year look back, and they are going to start penalizing certain transfers. So one of the transfers is what we just talked about, gifting. If you add a child on the deed, now your house is exempt, but if you have rental property and you try to reduce the value of that rental property to you by adding kids on the deed, that's a gift. If you change the deed over to a trust, you give the house over to your kids in a trust, that's a gift. That's the kind of gifting transfer the VA is looking for. But they're also going to start penalizing annuities, the purchase of annuities. An example would be if you have, $100,000 sitting in an IRA. You don't want to take the money out of the IRA, it's a tax hit. You can't move that IRA money to a trust, that's a tax hit. So people will often invest that $100,000 still in the IRA in an annuity. And that annuity has what's called a zero cash value because you cannot turn that annuity back in and get your money back. It's irrevocable. And instead, the annuity starts paying a monthly payment to you. And that's income. sort of like the required minimum distribution that your IRA was paying you. And the VA doesn't like that because you just reduced your net worth by $100,000. So the VA is going to start penalizing that. It's going to be part of the look back. So that's the core main things. There's some changes to the definition of a primary residence. In VA world, primary homes are exempt, have always been exempt. They had a concept of a reasonable lot size was exempt. They're now saying 2 acres is exempt. So if you own a home that sits on 5 acres, then conceivably you have 3 acres of your property that's countable. There are some exceptions to that, like if you can't sell the 3 acres. An example here in particularly Jefferson County, where my office is located, if you're on septic, instead of public sewers, you have to have a minimum of 5 acres. Your additional 3 acres in VA world is not marketable and not worth anything, so you wouldn't have an eligibility problem. But it's something to be aware of. It's something that you want to use an experienced elder law attorney, VA accredited attorney to deal with, because those are the types of questions that the VA is going to be asking about on the application, and you want to be able to know that yes, my house is on more than 5 acres, but it's not marketable, so ignore that fact. These rule changes are coming quickly. The VA proposed these rules 3.5 years ago in January of 2015, and we have been sitting here all this time with no news on what might happen. There was a public comment period. There were, thousands upon thousands of responses to the proposed rule, and we heard nothing all this time. And then in September, the VA published their final rules. They made several changes, and these are the changes I've talked about today. The VA is going to start implementing and enforcing these new rules October 18th. So in terms of planning, we are coming up on a deadline for planning. If assets can be shifted prior to October 18th, you're clear. You can apply anytime after October 18th, and those transfers will be ignored. But if you cannot get transfers done before October 18th, then when you apply, they will be part of the look back. And the way the look back and the penalty is going to be calculated, for many people, a transfer is going to mean you just won't apply for the VA benefit for 3 years. So the sooner you start, the sooner that 3-year runs, and it is critical to get going if you want to plan ahead. So I have enjoyed speaking with you today. I know this was a lot of information, and it's a big change for all of us. I encourage you to talk with Kent about planning for your real estate. I encourage you to talk to a VA accredited elder law attorney, not any traditional estate planner, but a true elder law attorney, and start talking about an estate plan that takes into consideration long-term care expenses and how your money will stretch during that period of time when you need long-term care. Again, my name is Whitney Wilson. I'm with Elder Law of Louisville here in Louisville, Kentucky. My information and contact information for my office is on your screen, and I encourage you to give us a call and schedule a consultation to come in and talk about this more. Thank you.
I'm Kent Lee, Senior Real Estate Specialist, representing my 55-plus mature adult seniors and their families with the selling of their home.